Uh, Good morning to everyone present here. I, Avneet Kaur, member of Sambhav Initiative and moderator for today's session. On behalf of the organizing committee, I extend a warm welcome to our esteemed dignitary, Mr. Rajiv Rajpurohit sir, and to all the participants in this 2 week national capacity building program on family laws, court practice, procedure, and drafting, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. Where today's session is all about procedure and challenges for NRI divorce. It is my privilege to introduce our esteemed dignitary, Advocate Rajiv Rajpurohit sir. With over 12 years of experience in the field of law, sir is a highly respected legal professional specializing in family law, including matters related to divorce, child custody, domestic violence, dowry cases, and court marriages. Sir leads a fast-growing legal practice with its head office in Ahmedabad and a strong presence in Pune, supported by a dedicated team of lawyers and associates. Sir has earned considerable recognition in his field and has had the honor of being appointed as amicus curiae in matrimonial matters by the Honorable former Chief Justice of Gujarat High Court. His deep engagement with the legal community includes active participation in numerous conferences, lectures, and programs on family law and matrimonial litigation. With a growing clientele across Ahmedabad, Gandhinagar, Vadodara, Mumbai, Pune, and other regions in Gujarat and Maharashtra, Sir is known for his client centric approach, courtroom excellence, and commitment to delivering results. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you. Thank you so very much for introduction. Yes. So good morning all. I see that the audience mostly, I'll speak in the English and Hindi. I'll try if anybody is the Gujarati. I'll try my best that concept of NRI divorce, then procedures, drafting and challenges I'll be speaking on. So first I'll give a general introductions without taking much time on this formalities. Thank you for inviting me on this conclave and initiative by Sambhav Initiative, correct? Hello. Yes. Am I audible to all?
Yes, sir.
You can respond. Avneet Kaur.
Yes, sir.
Yes, Mr. Yes,
Yes.
audible.
So now the divorce is something which we will talk, but I come across the line where I read that a divorce, something when we speak, is not really a positive word. But in my experience of more than 12 years of practice, I came across that the matrimonial disputes wherein the spouse are litigating or the marriage is not successful, there has to be some amicable solutions. And moreover, the spouse who is going through the matrimonial litigations should always take in help of the law to resolve the issue. Now, I come across the line and I would like to quote that if you are staying in unhappy marriage, maybe tragedy in your life, if you are coming out of unhappy marriage is always a solution. Unfortunately, the marriage should be always successful, but if it is not happening, the divorce is the only option for either of the spouse. Now, if we talk general about divorce, before jumping into the NRI divorce, I would like to speak on a general divorce, what the litigant does the mistakes in taking up the decisions, or what they should follow. The litigant who are going through the matrimonial litigation of initial stage and they realize the moment that the marriage is not going proper, in that scenario the litigant always wait for situations where the things are not in their hand. So I always suggest that if you are going through the bad phase of your divorce, I mean matrimonial life, then you should immediately take a legal advice. Taking the legal advice on time will not only save your time, money, and energy, it will be always helpful to navigate your entire either litigation in the right direction, or it will have a peace of mind. Therefore, one should always take a legal advice, or I mean, say the conceptually correct on the point if your marriage is not going in a right direction or it is in a rough phase of your matrimonial life or matrimonial span. Now, see, nowadays, since it is a global thing and there are spouses, either both of the spouses are settled in the foreign country, either of the spouse, husband or wife, are settled in the foreign country, and therefore this become a global demand wherein the NRI divorce, I'll quote unquote NRI divorce, is the challenges for navigating their process. When it comes to NRI divorce, the first concept, without taking much time on this, the marriage could have been solemnized either on the any personal law, maybe Hindu, Muslim, or any personal law or a special marriage act, or I'll say if it is not even registered, the marriage is marriage. But when it comes to taking a divorce, what are the challenges? Mainly those who are settled in abroad facing the challenges. What can be the procedure, and how it can be smoothly navigated, and without even taking much time on this, it can be sorted out. I'll be taking in the very layman and general language the questions, the queries I receive. The first query we receive is that whether are we required to travel to India or not. See, being a legal person, it is very easy to say that it can happen without coming. But when it comes to litigation, when it comes to the litigant or a spouse who is going through or looking for a litigation, or rather looking for advice, they always ask, are we required to come to India? For those, the answer is very simple and straight. If you are settled in foreign country, if you are working there, just for the purpose of your matrimonial dispute, you are not required to come at all in India. Without, I'm specifically putting emphasis on this, that without you coming to India, without a spouse coming to India, the divorce can take place. Now, let me come to the procedure. Before going to the procedure, I would be giving a general idea about the divorce. Divorce, mota mota, there can be two way, either contested or a mutual. Contested divorce is always go on merit. There would be a trial. There would be an evidence. The spouse who filed a divorce needs to satisfy those grounds which are mentioned in the enactment and the provision. More specifically, there can be a ground for desertion, cruelty, adultery, null and void, the other grounds given in the statute. However, when it is a mutual consent, there is no need to prove any case. The requirement for a mutual consent is both spouse needs to agree on certain terms and conditions, what they discussed and what they agree. The moment they agree on those terms and conditions, become mutual consent divorce. Anybody who jump into, since this particular conference is all about ADR, I would again give an emphasis in the practical aspect. Any spouse who looks for, or a lawyer who advised to the person who is looking for an advice, always needs to suggest that before initiating any litigation on marriage, there should be an amicable talk to bring solution for matrimonial divorce. I give you the practical aspects. Most of the matter pertaining to the matrimonial disputes later or sooner get settled. Therefore, there has to be an opportunity for everyone or everyone involved, all stakeholders in matrimonial litigation, that they should have a talk. They should initiate the talk. Irrespectively, I'm giving again an example. Irrespectively, knowing that it is not going to have a successful mediation or successful talk, but one should talk. My experience says that many occasions we being a lawyer also feel that this matter is not going to be settled in such circumstances, but after a few sittings the matter gets settled amicably and with smooth way this comes to an end. Therefore, always has to be mutual consent. Preference should be the mutual consent divorce before initiating the divorce on merit. Now let me come to the jurisdiction part of NRI divorce. Since I'm speaking on NRI divorce, jurisdiction is applicable as like irrespectively NRI or non-NRI, but there is one difference which needs to specifically for NRI, wherein if your spouse is staying in a foreign country, then you have, the husband specifically also have the right to file the case where he stays. Other jurisdiction is as it is. The first is where the marriage solemnized, other is where the lastly resided together, third is where the wife resides. So in NRI cases, always they've been staying abroad. So there are two things which not comes in practical way, where if you are staying lastly resided together in the foreign country, then that jurisdiction cannot be there. If your spouse is residing in a foreign country, then jurisdiction cannot be there. But yes, the marriage solemnized, wherever your marriage is solemnized, you can very well file the case there. For filing the divorce, the essential condition and document which is required is the power of attorney, special power of attorney, for the purpose of contesting the case, represent on behalf. I'll be try to make it little easy to understand. For the purpose of power of attorney, how it has to be executed, what needs to be all contained there in the power of attorney, the instrument, the document. The power of attorney which needs to be specifically mentioned, and I would be advising, when you are drafting the power of attorney for the matrimonial litigation, you need to specifically mention saying that this power of attorney for the purpose of litigating against or in the court of law for against my spouse for the purpose of matrimonial litigations, and you specifically can mention the courts also. Let's say, for example, if your matter is going to happen in Gujarat, you can always say that either family court of this city, this state. You can mention the Honorable High Court and Honorable Supreme Court. The matter may travel up to the Supreme Court by way of any other proceeding. Therefore, one power of attorney you can execute specifically for the purpose of. Yeah, I'm trying to share one of the copy for your reference for if I can.
power of attorney, where you will have an idea that how power of attorney is going to be drafted. Yes, fine, it is not possible. But the power of attorney has to have a content of the litigations to have a specific court and against what purpose. Once the power of attorney is drafted, the power of attorney needs to be signed by the spouse who is residing in a foreign country. Once the power of attorney is with that particular spouse who is residing in the foreign country, the person needs to take an appointment of Indian consulate. It is very important. Indian consulate is the one authority who can identify and attest that particular document called power of attorney. And once the Indian consulate of that particular country attest the document, become a valid document. The document, once attested, has to come to India. I'll give you an example. I'll give you a specific case of the document which, after coming to India, how it is going to be executed in Gujarat. Let's say one spouse is staying in Canada. He has a draft of the power of attorney. He will take a printout there. He will take an appointment. Online appointments are available by Indian consulate. It is very simple. You need to go to the particular site of Indian consulate. There are some columns of executing the documents. There are another column and options for a power of attorney. Then you have to put certain informations, and then your appointment would be there. Once that appointment is done and you have done the necessary formalities before the Indian consulate, the document comes to India, and once it comes to India, I'll speak about the Gujarat. The document has to be registered before the SRO of respective address. The purpose of registering that document of SRO at SRO, sub registrar office, that any document comes from the foreign country has to have an entry of that particular SRO, and there are nominal fees. Stamp duty needs to be paid. As per my information, last document I have received, probably it is 300 rupees in Gujarat. Once that document is attested by the sub-registrar office, and sub-registrar office takes the note of that document that the document has come from the foreign country, it is registered, the necessary fees has been paid, and thereafter the document again will be handed over to the person who is going to take a power of attorney here in India, or an attorney. Once that document comes, thereafter the person who is going to represent that spouse who is in the foreign country, called a power of attorney holder, will have the signatures, put the attestation, it has to be notarized. Then it become a complete document, the complete power of attorney. So once after the complete power of attorney is done, the next process, or simultaneously, there has to be a draft of the divorce petition or any matrimonial divorce. It is not something divorce, it can be restitution, it can be divorce, it can be other thing also. Any other proceeding in respect to the matrimonial litigation which can be filed in the family court, since we are speaking specifically for the family matters. The draft comes when the draft is ready. Then there has to be a filing. When it has to be filed, the entire draft, let's take a mutual consent divorce to be filed. The mutual consent divorce draft is ready. The parties has approved the draft, and then it comes for filing. The person of a power of attorney holder needs to remain present before the registrar, and once the person is before the registrar, he needs to sign on behalf of that spouse who has given a power of attorney to the person. There, subject to the satisfaction of the registrar of the family court will allow the filing, put the case number, and the filing will be done. there again it is very important. If it is a mutual consent divorce, both parties can give a power of attorney to their respective person, and even the both are not in India, then also the mutual consent divorce can take place. The same procedure, once the filing is done, there will be a date by the Honorable Court. Honorable Court when gives the date, in that particular date, the general procedure for the divorce is, one, there is a conciliation process. Thereafter, there has to be an affidavit. And thereafter, there will be a video conferencing. And after the consent over the VC by the Honorable Court, then divorce will be granted. This is the steps. Now I'm taking you into detail that how these steps has to be fulfilled and completed. Generally, practically, when there is a mutual consent divorce in regards to the NRI, since the parties are represented through the power of attorney, the conciliation process can be avoided. However, the next step for the purpose of giving the affidavit, that is a very mandatory process. It is a second motion called. In that, there has to be an affidavit. Now, affidavit cannot be signed by the power of attorney holder. Therefore, again, the person who is in the foreign country needs to sign, get it attested, and send it back to the attorney, a lawyer, or that power of attorney holder. In that case, once that affidavit is filed, the court will examine the authenticity of that affidavit. To examine the authenticity of affidavit, the court will ask the power of attorney. The second, because I'm talking about the mutual consent, since consent is very important, and hence to again see the authenticity of that particular document, the next process is to move an application for the video conferencing that can be independently filed by the lawyer. Therefore, there is no need of getting any sign on that particular application, and the Honorable Court once allow that application that the parties are allowed to appear through the video conferencing, since generally the court will allow, knowing that the parties are in the foreign country, and therefore the courts normally allows that particular application. And once the application is allowed, subject to paying certain cost of all infrastructures, it again a discretion of the Honorable Court. Court may grant a cost, court may not grant a cost. So therefore, whatever the court order, accordingly we need to follow. And once the court pass an order, thereafter VC can be taken place. It can take place, and accordingly, once there is a VC, without fail, both spouse or any of the spouse who is in the foreign country needs to remain present through the VC. Again, I am giving an emphasis that this is very important procedure for NRI litigant who is looking for a relief or a divorce by way of mutual consent. The consent only can be given by the spouse. The power of attorney is only for the purpose of representing and signing on their behalf. The Honorable Court is going to conduct the VC. There are certain forms where court is going to ask about the details. Those details, country, address, date of marriage, date of separations, and then subject to the satisfaction of the court may show that particular affidavit which I have earlier spoken about, that the affidavit has to come from the foreign country. That certificate the Honorable Court can show to that particular spouse and make sure that signature is correct, right, and it is given by that spouse who is giving consent for the divorce. Therefore, once the spouse give a consent, and even some judges specifically ask the questions about the power of attorney and make them available on the video conferencing and ask that is this the person who is your power of attorney? Is this the person whom you have given the power of attorney? Court may go beyond and ask that is this the person who is your relative, friend, known, parents, or anybody? Then court may go to any extent subject to the satisfaction of court for the purpose of taking a free consent for the mutual consent divorce. Once the court is satisfied, after taking consent, showing the affidavit and signature, then the Honorable Court put the matter on the order. Therefore, these two parts, three important documentations are different for the purpose of the divorce in India or the divorce who are for the NRIs. Those things need to be taken care. As far as other things are concerned, everything is normal. Now I am coming to the contested divorce if it is not mutual consent divorce. See, even in the contested divorce, again it is possible that divorce can take place without even coming to India through the power of attorney. However, there will be little difference and some technical part which needs to be taken care. Pleading can be done by the power of attorney. However, when it comes to evidence, in that circumstances and that case, one needs to normally remain present before the court. But the cross-examination also can be conducted through the VC. However, when the cross-examination needs to be conducted, or the person who is sitting in the foreign country needs to and wish to have the cross-examinations or depose himself or herself through the video conferencing, there are certain rules for the VC. Those rules are generally same, but those rules are framed by the Honorable High Courts and those rules has to be followed. If I speak about the Honorable Gujarat High Courts, there are now amendable rules. Earlier there was 2021 where this talks about that what are the criterias needs to be taken care when you are cross-examine witness or a cross-examine the person through the video conferencing. Those rules you can go through all, but those rules takes care of all necessary things, that it should be fair, it has to be independent cross-examinations, there should not be any tutored, because since it is a VC, there can be some material which can be having impact on the witness, and hence there are procedure that there has to be a document provided before, there has to be transmission of those documents. Thereafter, if required, your ID proof and address proof has to be submitted, and the court may direct for the purpose of court point and remote point. You may need to go to the embassy and take an appointment for the purpose of video conferencing. So these are the rules which needs to be taken care for the purpose of if you are going to the contested divorce, and if you wish that it has to be through the VC or through the video conferencing. Now, every court, most of the courts are having the VC available, video conferencing, and the Honorable High Court and Honorable Supreme Court also. Time and again made it clear that in a matrimonial cases, there can be a VC and there should not be a strict rule for the purpose of adjudicating the matter of the VC. And hence, every court now favors for the video conferencing subject to fulfill of the rules and discretion of the honorable courts. These are the things which needs to be taken care. Now, another things which needs to be taken care is when you are drafting every documents, you have to mention your present address, you have to mention and give the documents of that particular address where you are staying in the foreign country. The another thing you have to mention your passport number on other affidavits, and the power of attorney holder. The other thing you need to take care of, that as and when you are going the power of attorney, you have to take an appointment. The most important thing is, then when the documents, whatever documents comes from the foreign country, you need to keep that record of that document, then when it has come to India, who has received it, and the court may ask the particular query about that when this document has come to India. Specifically when SRO, you go for the registration of the foreign document, they ask for the proof that which courier it has come and by which date it has been received, when it has been dispatched from the foreign country. To make the authenticity of all such small aspects, the 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 respective authority on honorable court may ask these few questions, and therefore these are the practical things you need to take care when you are looking forward to go for a mutual consent or any contested divorce or any other proceeding for the purpose of this. So it is not that complex, however it looks like complex, but it is very easy once you go for a practical aspect. In my understanding and advice, always you have to see to it that document has to be have a clear drafting with the purpose of understanding for any of the honorable court or authority. That has to be very clear content, and the drafting which you are mentioning or content which you are going to put in the your draft has to be have a clear understanding of the terms and condition if it is mutual consent. So this is all. I believe you must have had a clarity whatever I tried to convey for the purpose of those who are looking for any matrimonial litigations before the court or going through the matrimonial litigation before the court. These NRIs can take care of these basic things and make the process easy. Correct? So yes, Avneet, if anything is required, I can put more on this.
Okay, sir. Thank you very much, sir, for your insightful and practical insight on this particular topic. Yes, please. Any question, query from participants? Please raise your hand or put the question in the chat box. Yes, Mahendra Ralan.
Yes, please.
Hello.
Yeah, please.
Yeah, good morning, sir. Good morning.
Yes, good morning, Mr.
Yeah,
Mahendra.
good lecture and all. I enjoyed it. Only one question is ki when you talk about the power of attorney to be executed abroad, no? They attested by the consulate and all.
Yes.
Is there a two-stage stamping or stamping only in India?
No, I didn't get your question. You please little.
Power of attorney to be executed, no? Special power of attorney you mentioned about.
Correct.
So when you go to the consulate for appointment,
Correct.
so there is a need for a power of attorney stamping abroad also and in India also when it comes to India?
No, I tell you again. See, attorney will be drafting the power of attorney, which says that I so and so give the power of attorney in so and so for the purpose of so and so, where these are the act can be performed by the power of attorney holder so and so filing wakalatnama etc extra this and represent me or something, right? This is one thing. Once the power of attorney drafted, I am telling you very practical approach how we execute it. Okay, you can send it to your the person who is going to sign there in the foreign country. He can take a print there, right? And he can take an appointment. The simple documents will go before the consulate. Consulate will check their visa. Consulate will check their passport, and consulate will only make the stamp there that yes, this person is here, right?
Okay.
And consulate will only attest that particular documents that this is a power of attorney. Yes, the person has come, he has signed before us, and we are authentify this document. Okay, so this is the only purpose, and then the document comes to India and other things take care. Will take.
Okay, nice. Or stamping has to be only in India only. That's all.
Stamping is to be having on the consulate there, and the second stamping has to be in India.
Yes,
Correct? So first
300 rupees. Yeah.
Yes.
Okay, nice. Thanks so much.
Yes, any other question, participant? Well, yes, question for participants are how long it takes to get a power of attorney? Are there any standard format in the website of consulates?
I believe, see, I try to share the copy. If it is available in my this system, wait, give me a minute. I'll share. There is a document share. Put rename view. If I can, there's no format as such, but yes, if you have any of your like book, for I can suggest one book if it is available. It can be solve your problem. Yes. So there is one book by the Sarkar, Draftsman. You can refer that book, right? There are many draft and there is a specifically draft given in the power of attorney also for the foreign. You can go through and accordingly you can make the draft. I don't have available or I'm not able to share rather. Correct. So this is the Draftsman is the one by the Sarkar. You can go through, you will find the format there.
Any other question, participants?
Anybody who look forward, you can have my contact detail. I'll specifically provide for that if I'm not able to. Anyone look for any assistance in this regard.
So when suppose the failure of entire process, then what happens?
What do you mean by failure of entire process?
Not happens compulsorily. The party
No,
have to
this has to be
consent.
followed. This has to be followed, and if it is not, then court will pass the necessary order on the merit. But for that mutual consent, it has to be followed. This is a simple and thumb rule process. Court cannot go beyond without taking consent, because the consent has to be have in two form, and that has to be video conferencing through, which I have elaborately told you that the consent which is given has to be have a through that particular spouse who is sitting, and court will ensure that consent through the VC. Then only court will grant a divorce.
There is no experts.
Ex
Expert.
parte is there, but in contested ex parte is there, and then the ex parte rule is applicable as like normal proceeding. There's no specific to NRI.
Then a question from Mohammad Refuzuma. What jurisdiction issue arise in NRI divorce cases comparing to country? Are the same or different? Like,
They are same, but as I told you, the jurisdiction mostly there, the marriage solemnized is a practical advice, since or the wife, if other spouse in the contested cases, if this wife resides in the place, like say, take an example, the husband is in US, wife is in Gujarat, Ahmedabad, correct? Then that person can have, the person who is sitting in US wants to file a divorce, then what can be the jurisdiction? Then the jurisdiction is if they lastly resided together. For example, they lastly resided together in Vadodara, then the first jurisdiction is Vadodara. If they married in, let's say, Surat, then the Surat is the jurisdiction. And the most important is, if the wife resides in Ahmedabad, then wherever the wife resides, then in Ahmedabad also they can file, because wife is residing. So section 19 of the Hindu Marriage Act, if you go mota mota sabka ek hi hai, but section 19 of the Hindu Marriage Act will help you to understand the jurisdiction.
okay, sir. Sir, like marriage happened like USA. One party came to in India.
No,
Like
the marriage
wife is
happening. No, marriage happening in US is not going to be dissolved in India.
okay, sir.
There are
One
many concepts of section 13 of ex parte, and this will take a long time. I have given you basic idea, but if
okay,
let's say there are practical problems, if the divorce taken in the foreign country, then what are the remedies, whether that is valid in India or not. These are more concepts, and that needs to have a lot of discussion. But I can give you an idea. This also a query comes when the foreign decree is taken. Both spouses has taken the foreign decree from the foreign court, and whether it is acceptable in India or not. These are the common queries comes. But yes, in my
yes,
answer, it is acceptable because both the spouse have surrendered to the foreign jurisdiction. There are Supreme Court judgment if both spouse takes the mutual consent divorce, even they are married in India, but they are in the foreign country, they takes the mutual consent divorce. Then in that case, the Indian courts can recognize that divorce, since they themselves has tried and surrendered the jurisdiction of the foreign country. But yes, If one of the spouses filed the divorce in foreign country and thereafter the another spouse is in India and the another spouse challenge the validity of that divorce, and that case that can be always challenged, since the other spouse can say that it is not the divorce which I surrender myself because I was in India and it is taken without following the procedure of law, or rather say back of my behind in the ex parte, and hence the honorable court in India will say that it is not conclusive as section 13 of CPC says. So this is,
Okay.
so these are
Uh,
more aspects which we can cover on in the any other session, but this requires the another aspect in this. I have just given idea about the procedure for and procedure and drafting.
Sir, good
Yes.
morning, sir.
Good
Yes,
morning.
yes.
Sir, we have come across an incident wherein
Hmm.
the party husband has given power of attorney
Hmm.
to the father to represent his case in India.
Correct.
And when it comes for deposing of the evidence, we
Hmm.
have requested the court that the party should himself appear in the court, because there are some personal questions which should be asked by the other side advocate.
Correct.
But the husband who is in foreign, he refused to represent himself, saying that I have given power of attorney to my father. It is my
Hmm.
father who is supposed to appear for all the proceedings in the court.
Hmm. Okay. Which state do you practice?
Right now, I'm in Karnataka, sir.
Karnataka. Do you have any
Yes,
rule
sir.
framed by the Honorable Karnataka High Court for the video conferencing? Like we have a video conferencing rule of Gujarat High Court?
Sir, actually, what happened? The husband was present at
No,
one
no, no. I'm
moment in the
just
court.
see. I'm giving you. I'm trying to give the answer of your query. Like every High Court, every Honorable High Court must have a rule, right, for a video conferencing. Let's
Yes, sir.
take example. We have a rule of Honorable Gujarat High Court, which is called High Court rule. Yes, a Gujarat High Court rule for video conferencing for courts, High Court and Subordinate Court 2021, right? So likewise, I believe there will be a rule, correct? You need to move an application before that particular court, right? That we need to have a video conferencing through the VC for the witness for deposition, and please be allow us for this, where we are ready to comply with all the condition as per the rules. So once you will satisfy the court about the rule and the formalities which needs to be taken care, right? Subject to, for example, if I am going through now the rules which we have in a Gujarat, right? So which specifically deal with how the witness has to be examined. There are forms given, schedule 2 and schedule 3, correct? So these schedule 2 and schedule 3 specifically speaks that which locations you are, what is the remote point, okay, what are your documentations of this, and such forms I'm not able to sign, but you can again connect with me and I can help you out to have a one judgment of the Honorable High Court of Gujarat, which specifically speaks that subject to fulfill of those rules, the parties can remain present through the video conferencing and there is no need to travel all the way from the foreign country to India.
I
This is
mean,
what the
that
crux of the Honorable High Courts.
family court where we are practicing, that we do not have facility of the video conference, sir. But
Mhm.
we have seen the party being present out of the court. The husband, he was being present out of the court, knowing that we have made a request to the court that he should be presented, because he should be present in the court to, I mean, answer to the questions which is imposed by
Perfect point.
wife, because even she wanted some in-camera proceedings to happen, but that party was refusing to appear because he says that he had given the power of attorney for his father to appear to the entire case.
So power of attorney cannot be in the deposition box. Only the person who is giving the witness has to be in deposition box, either way in person or through the VC.
Okay, sir. Okay. Thank you, sir.
Yes. I hope this was the only query, correct?
Yes, sir. Yes.
Yes. Yeah, I cannot hear you, Mr. Kalpesh. I cannot hear you.
Yeah, sorry, sorry. There's a question in the chat box. Wife and husband are not living together for more than 1 year and having a child also. Both are not talk to each other for 1 year and no action taken from both sides in this situation. What can be done?
Okay. So they are staying together, they are staying separate.
Not living together
They
for
are
more than
together.
1 year, having a
Okay.
child also.
They look for a divorce.
This is a situation. What can be done from both
Divorce is
sides?
the
So
only
this,
option. Even they are staying under one roof, but they can, as I talk, that the first have to be have that amicable solution, and if they talk to each other, they can bring the solution. Even they are staying under the same roof, but they are not performing their matrimonial obligations. The Honorable Supreme Court of India says that the place does not matter. Even they are staying under the same roof, but they are not performing matrimonial obligation, then it can be called as a separation, and accordingly they can proceed with the mutual consent divorce subject to their terms and conditions.
sure. I think so. We are done with all the questions.
Custody
So
and all can be decided, that best interest of the child, both can take a call.
true, sir. Yeah. So I think they are all questions are done. So thank you very much, sir. You are sparing a valuable time on this Sunday, and then you rightly discussed the NII things happens. Very
I
specific cases. Yes, sir.
sorry, I try to give you a practical aspect rather than theoretically, right?
Yes, sir.
Whatever practice we are doing here in Gujarat and in Maharashtra, so this was the practical aspect I tried to convey and to put before all
Yes,
of
sir.
you, that how
Definitely this.
somebody,
Yeah.
and
The idea.
whatever discussion we have done, it was any advice given is my personal opinion after my practice, that may not be considered as a legal advice always, and therefore this was only on the point of procedure and drafting. I tried what we follow, right? And anybody who look forward to connect with me can connect anytime. Any understanding required for the purpose of drafting, procedural, or any legal questions, the questions which asked the advocate from the Karnataka who has asked for the purpose of video conferencing and other things, because there is a, I also come across these situations, and we are still in the court of law for the video conferencing, that the why one needs to come to the court all the way from the foreign country to India just for the purpose of adjudicating the divorce and the matters. So this is all challenges comes, but yes, you need to, as per the law, whatever applications required to be moved, one has to move. So there are many other things like Section 13 of the CPC also deals with such cases. Then convention of the treaty, correct? So these are all required service of the notice in the foreign countries, right? So these are other things which also can be covered some other sessions, but as of
Sure,
now, practical aspects I try to give.
sure, sure. Thank you very much. So the idea was to particular program was giving a practical insight rather than Hindu law, Muslim law, or any other, the personal law, that practical insight that is much needed, because how we are teaching in classrooms, family one and two papers are there, and then especially like this kind of in nitty-gritty not being discussed in the classroom because they are not practitioner. We teach from books only, so those things are there. So thank you very much, sir, for sparing valuable time, and look forward to see you
Most
in future.
welcome. Thank you. Thanks. Thank you, everyone. Thanks for the opportunity. Thanks. Yeah.